Hello and welcome to MRA's 5-Minute HR Feed, the podcast where you get quick, practical information about a hot topic. In the time it takes to make a cup of coffee, you'll gain insights on hot topics and pressing HR issues. I'm your host, Rebecca Jacobs, and we are so glad you're here. Before we start, here's my usual disclaimer that the podcast is general information only and does not contain any legal advice. Now it's time to dive in. Hello, today we're going to dive into understanding what the EEOC means when it says undue hardship in the final Pregnant Workers Fairness Act regulations. First, let's do a quick refresher about the PWFA and how the concept of undue hardship ties in. The PWFA requires an employer to provide reasonable accommodation to a qualified individual's known limitations relating to or arising out of pregnancy, childbirth, or related medical conditions. This requirement applies unless it causes undue hardship on the employer's business operation. Remember that, unlike the ADA, an individual is qualified even if she cannot perform the essential functions of the job, so long as her inability to do so is temporary, and that she will be able to perform those functions in the near future. So, for example, during the length of a pregnancy, or perhaps a longer period of time after the child is born, potentially up to 40 weeks, it'll be on a case-by-case basis. We talked about that in a past podcast. So, in other words, an employer will need to reassign or excuse essential functions that the employee can't perform unless doing so would cause an undue hardship. So what exactly does undue hardship mean? So the bottom line is that according to the EEOC's interpretive guidance, undue hardship refers to any accommodation that would be unduly costly, extensive, substantial, or disruptive, or that would fundamentally alter the nature or operation of the business. So the regulations give us a number of factors to look at. And they say that no one factor is dispositive. So we'll look through those factors real quick, look through a few additional factors when we're talking about suspending an essential function. We'll look at what it means, what things we can't take into consideration when doing undue hardship, and then we'll look at an example. So the factors in the definition, we're looking at the nature and net cost of the accommodation. We're looking at the work site where that accommodation would be provided. What are the overall financial resources? How many people are there? What effect will this have on resources? What's the overall financial resources and size of the employer? How many employees do they have? How many facilities do they have? Where are they? A small mom and pop shop is going to be treated differently for the purpose of undue hardship than perhaps a Walmart or a Best Buy or some other large employer with multiple locations. What exact operations do they do? How is the workforce composed, structured, and how does it function? How geographically separate are they? And then what's the administrative and fiscal relationship of the facility in question to the overall business? And significantly, how does the accommodation impact the operation, and how does it impact other employees' ability to do their job and ability of the facility to do business? Now, we have 6 additional factors when we're looking at excusing an essential function. We look at 1, how long will the employee be unable to perform it? 2, is there any work for the employee to do? Will they actually be able to be productive in some other way? 3, what's the nature of that essential function? How frequently is it done? Is it something that's just done once a week, or is it done every hour? Has the employer provided other similar employees with temporary suspensions? We're looking at a consistency and fairness element there. Are there any other employees or temporaries or third parties who can be hired to do the essential function? And we recognize that's not always going to be feasible. That's my words, not the EEOC's about the feasibility. Could the essential functions be postponed or remain unperformed for any length of time? And if so, for how long? So that's what the rule lays out as the factors. Let's look at the things that we cannot take into consideration when we're looking at undue hardship. We can't rely on generalized conclusions. We have to have an individualized assessment of the current circumstances to show that this would cause significant difficulty or expense. If we've given this accommodation to another person in the past, it's going to be harder for us to say it's an undue hardship now. And also, I suspect this one's going to come up a lot. Well, we already gave her a different accommodation for her pregnancy while she was pregnant. So it would be an undue hardship for us to give her an accommodation now that she has a childbirth-related medical condition. That is also not going to fly. And then we can't demonstrate undue hardship based on the impact that that accommodation is going to have on other employees' morale. We can't base it on clients' or customers' fears or prejudices towards the pregnant employee. Or, for example, think about an employee who's lactating. Well, we don't want to have your consultant or whoever here because they're going to need a room where they're going to need to pump breast milk. That's not going to fly. That's not going to demonstrate undue hardship either. So let's look at an example from the regulations in the time we have left on this podcast. Example number 45 shows where there is a finding of undue hardship. A convenience store clerk wants to switch from full-time to part-time work for the last 3 months of her pregnancy because of extreme fatigue. There are 2 clerks in her shift. If her hours are reduced, the other clerk's workload increases. They'll have to do the work of 2 employees during the regular hours, presumably more than can be handled. So the customers won't get good service, the shelves won't be fully stocked, and store security will be at risk. And there's too short of notice in this example to hire a temporary worker. Accordingly, the employer is able to refuse to change her to part-time. But as you'll see in any of the examples that you read through in the interpretive guidance, the EEOC says, okay, maybe that's an undue hardship, but we still need to look at other accommodations we can offer. Like in this situation, giving her a stool, allowing rest breaks, of course, assuming that they also don't cause an undue hardship. Thanks for tuning in, and make sure that you get a chance to listen to the other podcast about the Pregnant Workers Fairness Act regulations. If you haven't yet, so you'll have a more complete picture of those rules. Thank you for listening to MRA's 5-Minute HR Feed. For this episode, be sure to reference the show notes where you can sign up to connect for more podcast updates. If you have questions, you can connect with MRA's hotline team by emailing infonow@mranet.org or calling 866-474-6854. Check out other MRA episodes on your favorite podcast platform, such as MRA's 30-Minute Thrive. And as always, make sure to follow so you don't miss out. Thanks for tuning in, and we'll have another hot HR topic in 2 weeks.